For judgment, item 1.
It's partly.
Item 2.
Partly.
Item 3.
It's enough.
Item 4.
Partly enough.
Item 5.
Partly.
Item 6.
Partly.
Item 7.
It's partly. No.
Item 8.
Partly.
Item 9.
Lord, item 9 of the list are appearing in VC. This is against the CBI. The CBI must have filed this. We are
1 minute. 1 minute. These are judgments, not the items. Partly enough.
Item 10.
Partly.
Item 11.
Partly.
Item 12.
Partly. Yes.
Yes, the Lordship's permission, may I mention, disposed of criminal revision and filed an IA for modification. Notice was issued, as it hasn't been come after that. Next Tuesday.
Not you don't decide the date. And you should get the order also and sign it.
Please,
Let us
I leave it to
understand how the board moves.
Please, I leave it to
Never ever say that.
Please. I'll
Always
just
you
request-
have to request to the court.
request.
Don't say you fix in that day.
No,
Don't say that.
next Tuesday request.
This is because you are a youngster. You must
Yes.
know how to articulate.
Please.
Okay, we'll see.
I'm so grateful.
Yes, sir.
Well, item 4 of the weekly list, that is a priority to the, that criminal appeal 212.
I think we have called for report. Let us see what report has come.
Well, he is there, I have also taken steps. He is there.
You got it.
Yes.
Then we will.
Well, may I play 2 weeks after?
Okay, no problem. You
Two
should
weeks
report.
after,
it.
2 weeks after.
Include next
212.
leaving 1 week thereafter.
2 weeks after.
Okay.
May I seek the pardon of Lordship? Your Lordship, this matter is listed on prior to the Tuesday, like on 6/17. So Your Lordship has given a direction to list this matter today itself, but for some reason. it has
What
not
matter
been-
is that?
Same, my Lordship. FR question.
Why this has come to this court?
Your Lordship, the matter is all about the misappropriation of the fund and all.
No, why? But this is not the assigned court. This is not the assigned court. Why this matter is to come to this court? Just verify whether it is assigned court or not. Okay?
It is assigned to this court itself, Your Lordship.
How it is assigned? Whether the Chief Justice is assigned to this court?
Okay, I will verify. Your Lordship.
Verify it. Okay. Yes.
Any mention from the list?
Item number 15, my lord. I pray for an adjournment on behalf of Shubhra Mahapatra.
These are weekly list. Don't worry about it. Yes. Let's start. Any mention? No. Yes. Start.
Report item 1.
Got the report, sir?
Report has gone personal life.
Give 11.
Report was came personal life. But on one we search for the information could not be traced.
Could not be trusted. Take the report and for hearing. For hearing. Okay. Take it. Yes, next. 99.
Item 2.
2.
There are 2 appeals. 2 appeals. One is the,
Got the report, sir? See, this is CBI.
yes, Lordship, CBI.
Yes, you got the report.
The Lordship, my instruction is there are 2 appeals. One is the 120
Yes, yes.
99.
Uh-huh.
The sole appellant has already died, and I have filed a IA for substitution of widow. Yes,
Already filed, huh?
already filed.
Widow is also 72.
72. My instruction is he is Lali.
Okay, we'll apply. Oh. The sole appellant is the 122, huh? Sole appellant in the present case stated to have expired on
Died on 29 to 2020.
29,
29 to 2020.
22. Thereafter, the widow of the convicted deceased appellant has moved the present application under 394 CRPC to leave to continue the appeal for the reasons stated in the application. The same is allowed, and the appeal is to issued for hearing. Okay. Okay. Next.
Fix it.
What about the other one? 123.
The one is alive.
Right. So get ready.
Maybe fix a date for hearing.
Yes. Get ready.
Item 3 also alive.
3 also alive.
Yes.
Report has come. Okay. 3 also alive. Huh? Sole appellant Omyu Kumar Das.
Yes.
Stated to be. Okay.
Your
Next.
lordship may fix a
Four.
date. Your lordship may fix it.
Next weekly list we will include it. Okay. Okay. This week it won't come, but next weekly list we will include. Okay. Yes.
5.
5 maybe call for the
What happened to
report.
4?
5.
Mention.
4 are
Right. Mention.
admin.
Okay, right.
5
5.
maybe call for the report.
Report.
CB.
156 3 2000. The just check it up whether the report has come.
CB. CB.
In 2000, he was 48 years. It appears to be. Do you have any report? Yes. You have a report?
State.
That's what.
Vigilance.
Huh?
State vigilance.
Vigilance. Okay, State of Odisha. Vigilance, Mr. Rijvi. Got a report or you will have to get a report? Okay. Which Vigilance SP? Just check it up. Vigilance SP. Just give the file. He'll tell. Give the file. Just check it up. Huh?
Yeah.
Check it. Okay. And tell the which area. Take. Next. There are
Item
two.
6.
There are one government appeal is also there. Give the item 5, huh? Mr. Rijvi. 6, yes.
He is not with me, I pray to verify.
This is also vigilance. No, this is not this. No, this is vigilance. 13 of PCL. Just check it up. Give it. Give this file. Vigilance file. 6 also give the file. Item 6 also give the file to Mr. Rijvi. We'll see. 7.
May I please, your lordship, I'm appearing on BC.
Yes.
This matter has already been had in the past, but I am supposed to receive the whereabouts of tenants. And in one matter I have received. And
No, see, it was stated that the appellant number 2, 1, 2, and 11
Yes.
expired. You have to verify. Have you verified?
Yes, I have contacted the IAS.
Okay.
He will,
The order
send
dated
today.
order dated 12/3/2002. Then okay, let it be there. Huh? Pass over. Let it be. Pass over. Yes. Next.
Item 8.
Item 8.
Yeah, I'm appearing as in person.
Yes. What is this? Why for this matter has come?
I had filed and I had to vacate the stay orders as which it is continuing since last 2 years. and nor he is paying any maintenance.
Now, which, 1 minute, which IA you're talking about? Which order, by which order the stay was granted?
Upon the order on 13/2/2024.
13/2/2024.
That is 2 bracket.
13/2/2020.
It is the order of down the district and session judge. And in this honorable court, it's on 16/5/2024.
Which order you want vacation?
That's
16/5/24.
16/5/2024. Your Honor, my advocate is going to appear.
You are appearing.
Today, he has requested me to.
What is this matter? See, lot of efforts has been taken by everyone to see. Both of them are lawyers,
Yes.
and I believe they started enjoying fighting the case.
No, that is one aspect.
The whole difficulty we've tried to solve the dispute, but nothing is moving. How to go about it now, since you have
And
come?
both also know that by the process, they neither they will get something, or by the only 7 except the
So let
killing
them,
of time.
let them live in peace at least. Let them separated, and whatever alimony, whatever is to be paid. Why they are spoiling their life, I don't know. There is a small, there is a child also from the marriage. I have interacted with the child and interacted with both of them, but nothing is working out, it seems.
That is they admitted.
And one petition after another.
It does not solve the purpose matter. By the
This is not the way of, either this way or that way you do it. If you can't live together, it's better that separate. What to do? You suggest me what? I'll take it up day after tomorrow.
Yes, well, that will be better.
Since you have come now, day after tomorrow I'll take
Madam,
it up.
that will be better.
Just think over how
Yes,
to,
madam.
because of your large experience
Madam,
may
I will,
help,
madam. I will, madam.
because both of them are the member of the bar. So you are also bar counsel.
No, that's not it. Unnecessary litigation, there is no meaning for it.
So there is no meaning. We keep on fighting, moving application after application, and we will decide this way or that way. That's not an issue. Issue is how to
Resolve the things.
resolve the things
permanently.
for all times to come.
Madam.
I'll take it up there.
Madam,
tomorrow.
Hon'Ble.
Okay.
Hmm.
Hmm. Write it down and give with both Sambalpura.
I can see ready. I can serve it also, so I have to get it.
Paper book. Take it, no direction. You can take it up. Now you conveniently avoided this court. Now it has come to me. What? Okay. Now you take the paper books. Paper books are there. Give a copy. Huh? Take in pen drive and everything. That will be more convenient. Paper books are there. Extra copies. Take it now. Extra copies. दे दो एक. काम करो. दे दो. Single copy, section sir के दे. Give a copy. He will prepare paper book and give us. Give. Section extra. अच्छी तो हाँ section तो the paper book is ready in both the matters. Mr. Ejwil and counsel appearing for the witness permits that the copy of paper book may be supplied to him. During the course of the day, the JC is directed to supply the copy of paper books in both the matters. During the course of the day to Mr. Ejwil. Okay. Yes.
564.
564.
Item 9.
In both the cases, paper book is there. Okay.
Item 9, my lord, Mr. Sarthak Nayak is appearing, and after Mr. Sarthak Nayak concludes, may I be given some time to address your lordship?
No, this is the revision.
Yes, this is modification and clarification they have filed, my lord. It is their carriage of
What
proceedings.
clarification you want? Who has filed this application?
We have filed this application, Lord.
What clarification, Mr. Naik?
Yes, Your Lordships.
Which
Your
paragraph?
Lordships, 15 lakh cash was seized, Your Lordships, and Your Lordships are directed on 13/3/2025 to release the said amount to Sri Lakshman Srinivasan upon filing of certain conditions.
Yes.
Only one small difficulty, Your Lordships, is that seized cash, Your Lordships, for its safe custody was deposited into the current account, Your Lordships, maintained by SBI UOB Kolkata in Vikas Bhavan. This bank is, your lordships, exclusively operated by CBI UOB Kolkata for depositing cash amounts recovered during investigation. But the problem, your lordships, is that the seized amount has already been deposited in the said bank account and not in the physical custody of CBI. Therefore, your lordships, it is not practically feasible to release the same physical cash that was seized from the petitioner's office. It is also not possible to provide the denomination, your lordships, as per the order, and the serial numbers of the said currency notes. Lordship, therefore, we can do an NEFT or a draft, whatever your lordships will. There is a practical difficulty in carrying out order, your lordship, because it is,
All right. Which paragraph is creating problem for you?
lordships, my junior will show
Which
it.
part of the direction?
Milord, I have the directions. May I be?
Yes,
Para
yes.
11, your lordship.
Para
Para
11, huh?
Yes.
11, which part? Magistrate should take
Milord,
measure
11.
to ensure the seizure of the property is not retained in jurisdiction. Investigating officer must regularly. No, these are para 11 are general direction. In your case, what is the direction?
Amount of 15 lakhs to the accused petitioners through demand draft or any other bank instrument may be added, your lordship.
Where is it?
In paragraph 11, in light of the above discussion and considering the judicial precedents, this court is inclined to direct the release of the seized amount of 15 lakh rupees to the accused petitioner.
Para 11.
Yes, your lordship. At page 14 of the judgment, your lordship.
14, huh? Watch 14. Okay, 14. 14. In the light of the discussion, consider the judicial president. This court is inclined to direct the release of the amount of 15 lakhs to the accused person, subject to the condition that ensure both the integrity of the investigation. Then what do you want to be added here?
Your lordship, 15 lakhs to the accused petitioners through demand draft or any other bank instrument may be added, your lordship.
Yes. What is your problem? You are interested in your money.
Milord, I don't have any problem, but the thing is that I have already filed a contempt application also regarding this.
It's all right. There is a practical problem. They are not able to do it. I'll add it.
Milord, kindly hear me for a moment. It's fine, Milord. I don't have any problem in getting my money either in NEFT or in demand draft or whatever.
Mr. Sinha, the currency notes are not there. They have deposited. They want to return you by way of draft or any banking instrument. That's all. You are interested in your money, you will get it.
Milord, that's correct. I am not opposing to that. I am giving my consent to that. But my lord, one thing, while the entire submissions were made, at that point of time it was stated that.
All right. Let us. You want to keep on arguing? Then I'll then issue notice, and this will go on and on.
I would not be arguing. As your lordship deals with.
Better I'll clarify so that you'll get it. It's as simple as that.
And along with the contempt application,
the reason stated in the application for modification, same is allowed. In para 11 of page 14, para 11 of in the direction, direction is modified in the following manner. Inverted comma though, in the light of the above discussion, considering the judicial precedent, this court is inclined to direct the release of the seized amount of 15 lakhs, bracket 15 lakhs, to the accused, either by the bank draft or any other instrument. Subject to
bank draft, Milord. Let it be only bank draft, Milord.
Any other instrument subject to the certain condition that ensures both the integrity of the investigation and the smooth conclusion of the trial. Inverted comma close. The para 11, the first part of the para 11 for the judgment dated 10/4/2025 shall be replaced by the para as mentioned above. With this modification, the application is allowed. Yes, next.
Period will not be.
Right on, Mr. Sinha is appearing for the.
Oblige your lordships.
And Mr. Naik appearing for the CBI. Yes. Next.
We have already complied with your lordship direction, Milord. Everything has been put in.
It's all right. It's enough. For every matter, you need not argue.
No, Milord.
Even if it is in your favor, why are you arguing? I am just.
Time period, Milord.
Mr. Naik is trying to comply the order. There is some practical difficulty. Therefore, they move the application. This have to be.
Only a time limit will be given.
No, I will not. In his application, you can't get the relief. You should have moved the application. Whatever he has asked, I am giving. That's all. Yes, next.
Item 10.
Item 10, Lordship, is a case where your Lordship is pleased to grant bail to the appeal party on condition that he has to pay the rest amount. That Lordship kindly see.
Where is the bail order?
Lordship, that is, Lordship kindly turn.
Sir, I am appearing for the.
And
Which bail? Where is the bail? Where is the bail order?
order? The bail is also attached with the CRM application, Lordship.
The bail order.
Here, your Lordship will kindly see. There, your Lordship, while granting bail to the person concerned, has been pleased to say that the rest amount, that is the amount is 47 lakh.
5 lakhs he has paid, huh?
Yes, during course, and he has undertaken that he will pay the rest of the amount soon after release on bail.
6
We
months.
believing that, okay, one.
6 months.
Believing on that, Lordship is pleased to grant bail. Order is 2024. March 2024, Lordship is pleased to grant bail.
If he,
Now it is around-
if he is there outside, he is not paying. If you go inside house.
No, that is the thing.
Sir, now
And
the
the
case is
peculiarity is
in
that- the
the
peculiarity is
case
that
has already.
in the CLM application,
That's right. You are absolutely correct. He has persuaded the court saying that I'll pay.
Yes.
Before bail was granted. But you know the law. These are not recovery proceedings.
that's true. But when it is a case that.
But why are you not paying? Forget about it. Why are you not?
Now the case is in last stage. IU is
That-
to be examined.
Is say
It is a flag of
The problem is you have made a wrong statement before court to persuade the court to grant bail.
yes.
This is what is the problem. For the purpose of bail, you make any statement and get away with that.
Yes.
He has taken already 5 lakhs without.
That's a different story. Can you make a wrong statement in the court and get away with that? That's the question. Whether legally it should be done or not, that's a secondary issue. But you have undertaken.
Sir, I file affidavit.
Nothing.
That effect I have.
Flag A.
File
Flag A
file
is
affidavit
affidavit where he says that within a month I will pay 3 lakhs. Rest amount is.
No,
60
I will
lakhs.
deposit it before
That
the
is-
court.
that is
Not I
not
will
the
pay
flag.
to.
Lordship, kindly see the
What is
flag
the
A.
stage of the trial?
File is allowed. IU is to be examined.
Case is under 420. 7
IU is to be
criminal
examined.
Hmm?
7 criminal actions of the similar nature. Amount involved is 47 lakhs amount. It is around 7,000. Now, how he is playing with the person, and the informant is an old man of 72 years old.
Now the last IU is to be examined.
That's not
Now it is clearly evidence says that there is a chance of I may be acquitted in this case. In that stage, they are filing this cancellation of bail, and he will take away the money. That is the evidence. I will file the evidence, Your Honor. Maybe
Then in the objection, why have you not filed?
Nothing. He has not filed an objection.
no, I
Rather,
filed
he
a-
has
I have
an-
filed the affidavit.
Already an affidavit at flag A. Let's make
Yeah, so that is
what he
affidavit.
said.
That
What
I
he
say
said.
that I will
Again, Mr.
Again, misleading, again,
No,
misleading.
that I will file a affidavit that I will pay 2 lakhs.
Then why this affidavit you file again? You say that I'll pay.
Sir, when court,
Then
court,
somehow that
you
is trying to
ask me
avoid
to
the
the
court
court.
process.
Why do not you deposit that amount? So that I file that I will pay.
These kind of orders are not to be imposed while granting bail. That's that.
Right.
But once you make a statement and persuade the court, generally court is not inclined. Then you persuade saying that okay, I'll pay it.
Yeah,
The court thinks okay, let it be recovered at least something. That's the idea.
Sir, I
of
have
giving.
already paid the 5 lakhs.
Supreme Court has
Supreme
categorically said these
That-
are not recovery proceedings.
that
Bail,
order has
you
been
can't
passed.
direct. Can't direct. That's the law. But the whole problem is, can you mislead the court?
Sir, for this reason, I have filed an affidavit that I will pay 3 lakhs, 2 lakhs. I will file before this honorable court. Deposit that court. I will not pay to the petitioner.
What I'll do is, you come out with clear, I will not cancel the bail. That's for sure. But I'll impose exemplary cost on you for having misled the court.
Repeatedly.
Exemplary.
Sir, I filed the
And that cost will go to him. That will not be counted also.
Old man, 72 years old, is suffering for the money.
At least 3-4 lakh rupees cost I'll impose on you by not cancelling the bail, saying that you have misled the court to persuade the court for grant of bail. But I'll not cancel the bail because bail can't be cancelled.
50,000.
And the bail said no recovery. That's the law. But since you have misled the court, therefore exemplary cost.
Repeatedly. Not only once, repeatedly. is
And
trying
you
to-
are filing another affidavit
Yes.
saying that again.
That when the court.
So
told me
this is
that
how
technically,
Now responsibility is from the court because the court asked me, I filed. You have no obligation to do that affidavit.
I'll
It's a
take
very
it, take
peculiar
up next
submission.
week, if you come out. You may be corrected that why he is moving this application today is he might have got the feeling that he's going to be acquitted
Yeah,
and
not
get
that
anyone.
exactly, not
So
that
therefore, that
exactly.
may be a reason also. I don't know.
Cost may be.
Acquittal conviction is not the issue.
No,
in
no,
this
sir.
matter.
Sir,
We have to see
exemplary
whether
cause.
He must be come after 6 months. And when you know that the trial is already lapsed in your hand and the accused going to be acquitted. Sir, the evidence is clear that.
Maybe you're correct. I'm saying
So that he came to this court back because I assured that I will pay that. He will take away the money. And the order passed by the honorable court that.
And have you filed recovery suit?
No, not yet, because we are proceeding in the trial.
Are you within limitation?
No, it is within limitation. I can
Then
file.
why don't you proceed?
Because the proceeding is pending now, under 4.
No, sir. No, last day, sir.
So this is not recovery proceeding.
No, not recovery proceeding. The thing is that this is a case where the person concerned
And if you are
has
under the
admittedly
impression that on the arm twisting method by criminal case, if you will get back your money, you may be wrong. File a suit.
That is true, Lordship, because there is a portion of
File a
law is
suit.
that. But thing is that what is his conduct? How he is reporting the court?
For
is what I
that
have to say.
only I will impose cost.
The thing is
Well,
that
maybe
to
whatever.
disable with the attachment person just to get a bail from federal
But on
law.
that ground, the bail can't be cancelled.
But he has to be.
Because the Supreme Court has very clearly, very categorically passed the judgment and circulated to all the high courts and trial courts.
That
The
is
bail
there.
stays,
That is there, but the way how he has
no recovery.
that is there. But it is a case of clear mischief.
So therefore, I'll impose cost.
Repeatedly he
How
is
much
doing
cost
that.
you tell me?
50.
47 lakhs.
50 what?
50,000.
47
No.
lakhs is the amount.
Audition is just
Something
that,
bigger amount. Exemplary cost. Exemplary cost. You get some evidence. I'll take it up next week. Get some evidence which may indicate towards an acquittal.
Yes, sir.
Okay.
I have the document, every deposition, sir.
Okay.
But I will file it next day.
Get ready for 2 lakhs exemplary cost. Okay.
Sir, already taken 5 lakhs.
Let it be.
Sir, that
Why,
is no charge.
why are you
recovery.
knowing the law, why are you making statement
Yes.
and persuading the court to
Sir,
grant bail?
Next date will be given. I will apply this court.
Okay, that's I'm giving next week. I'm taking.
Appraising this
Next
court
week,
on what point? Whether he will
Point
get
of
acquittal.
acquittal.
Point of acquittal is there is submission that he will argue
You,
this on point
sir,
of
Better for you. For you to resort to order 37.
that I will do always. But thing is that this is how
This will go on. This will go on like this. I need not tell you further.
I follow them.
And then you lose limitation also
No,
in this process.
because I am just waiting for the result of the trial.
Exactly after 6 months.
I am appearing on being because the elect council being government council, so no trial will transfer to me.
Take it there. Okay. Next week.
Let's be calling this matter is short.
Next week.
Let's. And let's observe.
Let-
Let him come with the positive note. What would be?
Correct.
Let us see what he's saying.
Sir.
His 2 lakhs will be wasted unnecessary. Yes, next.
Item
11. Yes.
Item 11, my lord, on the last occasion, on 17/2,
Already.
my lord, no.
Everything is given.
No, it's
What
not
do you want?
compliance. My lord, that's why on the last occasion, Lordship may see the order dated 17/2.
The order.
Yes, ma'am.
applies
The Lordship
to
granted me the
state of Madras.
time to file response. I have already filed the response. And in the meantime also, I have obtained some documents under the RTI Act, which will show that, my lord, this is opposite part number 2.
What was the direction? Show me and what is
Direction is to consider the array application of the petitioner under the
of the substantive
old rule.
substantial compliance is full compliance. That's the law.
My lord, your lordship may see-
Contempt doesn't lie.
No, your lordship may see, after the
If
order.
you want strictly to be decided on law, substantial compliance is full compliance.
Yes, my lord.
And
But
they've given you job. What else you need?
they have given me job, but.
Show me the order.
Yes, sir. But as against a class 4 post.
No, show me the order. Show me the order. Which order was not complied according to you?
That is the order dated.
Yes, the order
Tw- 12
12/9/23.
Yes, ma'am.
Okay, come to the operating part.
12.9 and the operating part, your Lordship
Mhm.
may see.
In view of the foregoing, I am of the considered view that the prayer made by the petitioner
Yes, 25.
above deserves to be allowed. Therefore, the writ
26.
disposed of with the direction to opposite party number 1 to consider the case of the petitioner for giving appointment under the RA scheme under so and so as a mandate
Yes.
so and so, since the matter is pending so and so, and appointment is the only direction.
Thereafter, they preferred the appeal and thereafter they went to
It's
Supreme
all
Court.
right. Appointment
Yes.
was the only direction. The appointment has
Yes,
been
sir.
given.
That is,
Then-
your Lordship is correct. There is no specific direction, but my submission.
No, we can't.
My-
In a contempt jurisdiction, you
No.
can't write down.
1 minute.
The
Your
applicant,
Lordship, Lordship, allow me one. My only submission is that there are 3 containers. Opposite party number, container number 1 is the government, WR department, 2 is the EIC, and 3 is the director. Madam.
in a contempt jurisdiction, can I add any other
no,
directions?
No, there is nothing. Madam.
Why
My
are-
simple,
why
my
we are
simple
wasting time?
submission before your Lordship, my humble submission that after the dismissal of SLP, the opposite party number 1, the file was processed in the office of the opposite party number 1 for appointment to the petitioner against a group C post mailers. That is the file I have obtained under the Act.
Perhaps I can't help you.
That I would like to show your Lordship
No.
that in spite of the order,
There is no direction. Give
That is true.
appointment and under RS
Your
scheme.
Lordship is correct.
Appointment is given, group C is given, group D is given, there's none of these two.
Nothing, right? Nothing.
Before the court. Madam,
Mr.
like
Your Lordship may grant me liberty to raise my grievances.
you do whatever.
File
Then simply withdraw the contempt. We will leave it to, sir, I'll not pass the order. The other grievances, you may agitate wherever is possible. If you withdraw it. If you ask me to write a order, then I'll say that it's a compliance. Think over.
I'll raise my grievances.
Withdraw it?
Yes, sir.
Right.
I'll raise my grievance.
Since the
Liberty may be granted.
LA's containers have filed, where is that compliance, this thing affidavit?
Compliance affidavit they have not filed as a.
Where is that order of compliance?
Only the order of appointment was handed over.
Where is that? Where is that?
That is order dated. That I have enclosed in the.
Where is that, sir? Shokas you filed, na? Shokas affidavit filed by the opposite parties.
Shokas and denunciation.
Where is that order? Where is that? That's what I'm asking.
Through a memo. On 17 to
Not scanned, it seems. 13-2.
13 to.
13-2026.
Yes.
Pursuant to the notice issued by this court in the contempt petition, the alleged contemnants have placed on record the office memo number 4578 of 02 dated 13-2026. 26 indicating that the petitioner, contempt petitioner, has been appointed under the rehabilitation assistance scheme, and the appointment letter has already been issued to him. It issued to him in view of the aforementioned substantial compliance. The nothing survives in the contempt petition. At this stage, learned counsel for the petitioner raises various objections. With various objections. In the contempt jurisdiction, those objections cannot be adjudicated or gone. Hence, he seeks to withdraw the present contempt petition to raise all the points in appropriate proceeding if so advice. Okay. Yes. With this supervision, contempt petition disposed of. Yes, next. Yes. What is this? Yes, item 12. Hey, Mr. Naik.
Yes, your lordships.
The sole appellant appears to be about 74 years. Get a report.
Yes, your lordships. Yes,
Huh?
your lordships.
Get a
Yes, your
report.
lordship.
Huh? Report. Well-being and status report. Okay.
Obliged, lordships.
Just you find out which take the original file
Yes, your lordship.
and note down which area.
Yes, your lordship.
Where from which the SP of which area is to be asked for giving the report.
Understood.
Take the file. Give him.
Yes, your lordship.
And
I'll see it from here. Your lordship.
see and
Yes.
give in writing.
Yes.
Item number this particular recipe so that we will write it.
Yes, your
It will
lordship.
be easier for you.
Yes, your lordship.
Okay.
Yes, your lordship.
Spike Mal, your lordship, Sambalpur.
Let him see the file, your junior, give in
Yes,
writing
sir.
so that a specific order will be passed. It will be
Yes,
easier
your
for
lordship.
you. Okay.
Yes, sir.
Okay. Next.
Item 13.
1394 years.
But 13, the appellant was substituted by the legal aids. And
Acha.
pursuant to the last order to that, we have also served a copy of the paperwork to my learned senior.
Already
which is
substituted,
writing
huh?
for- I think a lordship may fix up a date.
It's a vigilance case.
Yes, ma'am.
Then we'll go ahead with hearing. Huh? Okay. Are you ready today? Ready? You are ready?
Let's.
2 o'clock.
Next week.
Why next week? 94 matter.
No, that's not.
It will never be heard then.
Even I had also.
Now we will read together. I have also not read.
Well,
we'll
there's
read
a
together.
part matter, I'll do it at the lunch. That is 28. Let it come next.
Okay. No, Thursday. Coming Thursday. Let it be there. We'll see. Huh? We'll see. Yes.
Item 14.
14. Because these are 91 matters. Yes. I want that at least till 95, whatever matters are there, we will finish it up. Then we will proceed next. 13.
Item 13. 14.
Okay, no? 14.
Item 14.
14 again. 14 is 75. Give,
Yes,
get the report.
I'll just give it.
Note down.
Yes, your lordship. I'm noting.
13. First is
14. Your lordship.
12 and 14. Huh?
Yes, your lordship.
Next.
Item 15.
15 also. 15 also. Alive.
Yes.
Report has come. Yes.
I pray for an adjournment on
Is
behalf
alive.
of.
Yes.
I pray for an adjournment on behalf of Shubhra Mahapatra.
This is the appeal
Item
of
number-
which year? 2000. Okay, let it be there. We'll
Yes.
see. In the list. Yes. Next.
Item 16.
Alive, huh? For hearing. Ready. 16. Vigilance. Report has come. 24. Now he was 76, now 76. Get a fresh report, better. 2 years has passed, huh? Fresh report. From which Sambalpur, huh? Vigilance Sambalpur. Okay. Yes.
Item 17.
Now appeal is confined to appellant number 1 and
2, 3, 5, 6, 7, and 8 died.
abated all except appellant number 1 and 4.
Okay. Then a file.
The short point is there. Then appeal. The fact of the case is that the docket is committed in the house of the PW1 on 16/1/1988 in the midnight by unknown persons.
395.
95. Stolen articles are from the bedroom of the PW1's father and mother, that gold and silver ornaments and 800 rupees cash. From the bedroom of PW1, golden and silver ornaments, cash of 1800 rupees, umbrella, torchlight, favorable wristwatch, and another communal ladies watch. These are the articles stolen. The accused person, accused number, the appellant number 1 and 4, they were arrested on 27/1/1988.
Yes.
They are put to TI parade on TI parade on 31/1988. 7 accused persons at a time were identified in the courtroom itself. And before the identification parade, that IO took the photographs of these 7 persons, including the appellant number 1. And thereafter seized some articles on 27/1/1988. No independent witness was my lord, locality was the witness to seizure. Police brought from far away, that is PW9. Far away for my lord, to be a witness to the seizure. These 2 points were raised, my lord. Learned trial court in the judgment specifically.
Then your
disbelieve that
your submission is TI period is doubtful, recovery is doubtful.
That was also admitted by the trial court, my lord. It is, my lord, I am placing only at paper book at page 10.
Page
10,
10,
page 19.
19, okay. Read that part.
No, it is page, my lord, it will be page 10 or 19.
It's all right.
10.
In page 19.
10, my lord.
10, okay. Read it. So far as the other expressions are
no,
concerned.
so far, my lord, para 9 above. Para 9 above, you'll also last portion from para last line of the paragraph 8, 2, 3, 4, 5.
Read, the context has to be seen.
In the circumstances.
In the circumstances, therefore.
It is difficult to rely on the identity made by PW1, 2, and 7 in TI parade, as there was every possibility of their having seen the accused person before the TI parade. Had it not been so, such of them would not have identified all the accused person without any hesitation and mistake. My lord, on basis of 1993 OCR, page 398, my lord, that was that in the TI parade conducted in court, not legal and valid. My lord, first this TI parade identification goes, my lord, in respect of appellant 1 and 4. Those are identified.
1 and 4.
1 and 4. Others are dead abated, my lord.
It's TI of 1 and 4.
1 and 4.
Regarding A1 and A4. A4.
Regarding that, the conviction was made on the basis of the recovery of the articles from the custody of from the house.
Para 9 deals with that.
Para 9 deal with that. My humble submission in respect of appellant number 1. Not a single article seized from the appellant number house or custody of appellant has not been dealt with. In entire judgment,
A1 no recovery.
No recovery.
A1 no recovery.
Has not been dealt with at all. And the conviction of appellant number 1 is completely legal.
TI. Very also doubtful.
Then, my lord, regarding appellant number 4, my lord.
A4, yes.
A4, my lord.
What is the recovery?
Recovery, they say, my lord, the one Panabata, in judgment it has been dealt with, the Panabata was recovered from his house, but evidence is something else, my lord. My lord, you will also kindly come to page 20.
20 of
the paper book.
Page 20, yes.
That is one line has been stated in the last part. One Panabata from the house of Barendra Jena.
Para 9 recovery.
Para 10, my lord. One brass Panabata.
Para 10 or 9? 9.
It is paragraph 15,
9.
my lord. It is paragraph 15.
Judgment.
Paragraph 15 of the judgment, my lord.
Where is that? Page 20?
Towards my lord, at page 20, one on the middle, exit, one brass panabata from the house of Barendra Jena under
1 minute, I'm not
Annex
able to.
under exhibit 9.
9, huh?
Only that is the sentence in the judgment. Against the appellant, not for.
Page 20 you're reading? 21?
20, my lord. Internal 20, my lord.
20. Which line? First provision shown.
Trial court judgment.
Oh, which line? The evidence appeared as well as the report.
Line 4, 7 line from bottom, my lord.
The second correctly shown. What is this? I do not want to discuss about the identity of the properties also. Again, also the land counsel for the defense. What was that?
One brass panabata from the house of the Barendra Jena.
I'm still not able to locate.
Only that.
Still not able to locate that.
My lord, page 29, your lordship can call.
29 you are talking about.
Page 29.
I am reading
Internal judgment, page 20.
29.
29.
Okay, 29. Yes.
Internal page of the judgment 20, paragraph 15. Towards that page 29, towards the bottom 7th line, my lord.
Yes.
One brass panabata from house of the Barendra.
Your pagination, the internal page of the judgment, which page of the
20, internal page is 20. Judgment.
Running page?
29.
Yes.
From
the house of the accused, Bhima under so one brass panavata, from the house of
Barendra Jena.
He's
appellant
4. A4. A4.
That is the material against in the judgment.
20. Para 9. Para. Which para?
10, my lord.
Which para is this? Para 10.
15.
Para 10, huh?
15, my lord. Pontar. At page, internal page 19, running page 28, para 15.
Okay, para 15 last.
That is only discussion against the
15.
Your lordship kind
recovery.
The material witness number 9, PW9, is the seizure witness. PW8 was the seizure witness.
And how will you come out of this recovery?
What type?
The recovery of Panavata.
Panavata, my lord. I am coming to that. This witness number 9, PW9, who proved it, does not belong to that locality.
Maybe.
No, my lord, the law is that when a number of persons are available in the village, why did police took one person from outside?
Come to 9.
PW9, at page, running page. Let's take that about this. Running page 107, my lord.
Yes.
Now he belongs to village. Mauja.
I have been to Jaleshwar.
I had been to Jaleshwar. At about 3 p.m., I was standing in Badabajar.
He was chance witness.
Pardon?
You were the chance witness, you were there.
Yes. Star witness is
chance witness. By chance you were there.
Chance witness. But when my lord the accused was taken to his house, in his village or nearby village, number of persons were available.
That may be, but his presence can't be doubted because in the beginning he says that I was in Jaleshpur.
Jaleshwar. He was taken to the village, my lord, of the.
Where the incident had taken place? That I was
He
in
was
Bazaar,
taken to.
at the IC
Incident
Bogarai PS came
Incident
there
taken on
and called me.
took place on.
How far it is Bogarai?
How far is the
The
Bhogarai?
incident where? Incident has taken place.
Incident at Napari village, Napari.
How far it is?
Is the Barendra Janat how village is Kasida.
A4 is Barendra, na?
Barendra.
Para 4, you come to Para 4.
Para 4, my lord, that place. We went to the house of accused Barendra, who was arrested in the village. In our presence, accused Barendra gave recovery of some gold and silver ornaments and wristwatch, which were seized in my presence. A seizure list was prepared. Is the Panabata is not there.
Then why the trial court is wrong then?
Trial court completely
wrong.
No.
Recovery is
Something
not
else.
only Panabata, there are many other things
Another.
recovered.
Panabata is not there. Man.
Panabata is rather not there.
Not
So
there.
trial court is wrong.
No.
Recovery is affected from you.
I rely on my lord. 3 decisions, but 4 decisions I could not bring.
Trial court is wrong, therefore you are here.
Yes.
Trial court is completely misread the evidence.
Yes.
Rather, more recovery has been affected from you.
Affected. Yes,
Then how that will help you?
My some humble submission. The TI period is completely clear.
TI period in I can understand A1. I can understand A1
recovery
because there is no recovery. TI period is doubtful.
If the witnesses are available in the locality, it is doubtful that to take a witness from outside.
Let us see in the cross examination whether you ask this thing. Seizure made in the village Kasida.
Cross examination is
on the day I went to the village Kasida for the first time.
The seizure was made in village Kasida on the day I went to village Kasida for the first time. For the first time, my lord. Village Kasida is about 16 miles away from my village. Bearing the names of the accused persons as told by me earlier, I cannot.
Show me the judgment. You put those questions. Show me the judgment. Show me the judgment. Now you understand.
Yes.
Show me the judgment that they were available. Villagers were available. Somebody from 16 kilometers away, 16 miles away. Why he was taken?
Taken.
As a witness to the seizure.
Yes.
That's what
I am
I'm
taken to judgment. Yes. My lord, I am taking to your lordship to 2003 volume 2.
Give me a copy. Give a copy.
Para 13 to 16.
Para
13 to 16.
13 to 16. Yes. The ratio, you tell me the ratio.
In regard to PW3, at page 207.
13, huh?
13, 1 3. In regard to PW3, the Learned Counsel contended that if we carefully consider the sequence of events as narrated by the witness, it is clear that this witness could never have have seen the deceased and the respondent near the house of the respondent at about 3:30 p.m. On that date, he drew our attention to the part of the evidence of PW3 wherein he had stated that after lunch, he had left his house around.
This is a case of 302.
395 is there, not only 3, not
364
364.
and 3. How
Not
it will help
true.
you?
That evidence is that he was not far away place, my lord.
No, you see, show me the ratio disantee of the judgment.
395.
He says that the seizure witness cannot be believed if he doesn't belong to that village. Locality. Show me.
That is there, my lord, he hasn't dealt with that judgment.
Which part? Show me. That's very important. But it is an
My lord,
appreciation of evidence. What is
my
the
lord, you
relevance?
will also kindly come to paragraph 13 last part, middle, my lord, at page 208. The prosecution has not explained why particular person had to be summoned from a places away from the house where the search was taking place. He also pointed out that this very witness has been made the punch for all the recoveries made by the prosecution, which also speaks about the credibility of this witness. Current counsel then pointed out that various contradictions in the evidence of the prosecution witness are to breaking open the lock of the respondent's house, switching on the light in the house and regarded to the presence of the PW9, the IO at the time of search. The learned counsel pointed out that from the evidence of PW9 himself, it is seen that he was there only till 11:30 p.m. in the night when the inquest and seizure were going on.
This is again appreciation of evidence in that case. Where is the
He is
ratio?
far away, my lord. Therefore, his presence, the other witness.
It is doubtful. That is how the court has appreciated the evidence of PW9.
Then para 16 you will also find. Para 16 is relevant. In this regard, prosecution relies on the evidence of PW4. We have earlier noted that PW4 is not a resident in the immediate proximity of the house of the respondent. He belongs to the same viradiri of the complainant and lives behind the house of the investigating officer, PW9. We find no reasonable explanation why such person was called to be a witness to recovery when there were any number of people available who were residents of the house in the immediate proximity of the house of the respondent.
These are appreciation of evidence. Where is the law?
We also noticed from the records that a large number of people were present at the time of recovery. Therefore, the prosecution should have come forward with some explanations.
This is no law.
My lord, that some explanations, it is here, there no explanation was given why he has been brought to from Jaleshwar town, my lord. There the prosecution should have.
Who is IO?
IO is PW14.
Have you put that question to IO? So
at running page 1, my lord. The PW14 124 running page. In the cross exemption, you will also find to. Cross starts from page 132, my lord.
para 11 just see. What is the reason? That's the explanation.
Para 11.
On that day, I left Jaleshwar.
In the Bada Bazaar of Jaleshwar town, I arrested accused Bangshidhar Jena and Boiragi Jena. On interrogation,
They confessed to have
They have
committed
committed
docketing.
docketing, took me as well as the
As well as the witnesses to the village son. The witnesses saying Jalandhar Singh, he was in Jaleshwar bus stand.
Barendra Jana was
He
not
was
there.
in Jaleshwar bus stand, PW9, and he was arrested. Therefore, he was taken. That's the
He
explanation.
was taken, my lord, for custody. My lord, the Barendra Jana was not there, arrested on that day.
Yes, see.
On day I left Jaleshwar in
that village, we surrounded the village
Ponchadana
and
village.
arrested Bhimo Jana, Sitaram Jana, Barendra Jana, Panchayat Jana, so and so at 4 p.m. today, so and so. So therefore, when the IO was leaving from Jaleshwar, he arrested Banshidhara and Bairagi Jana, Bangari Jana.
Yes.
And he along with these two accused, the other witnesses, PW9 was also there. He took them to the village. That's what the
PW9
explanation.
up from Jaleshwar, my lord. Seizure witness from when recovery was.
He was standing in the bus stand. That's what he was saying.
Bus stand thila bole need to pade
Very-
the unknown person.
You have not asked anything.
Then, my lord, another judgment I am giving to the losses.
You see, para 15, Barendra Jana then led us to the house and gave recovery of brass panabota, a lady's
That has
wristwatch,
not been proved.
so and so, gold and silver, so and so, indicating the seizure list, so and so, and before the witness prepared seizure list, and the trial court is absolutely wrong, saying that only one thing is recovered.
Then Panavata has not been proved. Independent witness has not said so. Panavata has been said. Police has said.
They identified Panavata.
The evidence is not, my lord, identified.
Panavata is identified by the TI parade.
TI parade it was identified.
In TI parade, Panavata is identified. The other things are not identified. Therefore, the trial court says that only Panavata recovery is proved.
But my lord,
one recovery is enough.
But independent witness has not proved that. PW9 seizure witness has not proved that.
That's an ancillary thing.
That is, it has not been proved, my lord. Another judgment, my lord. 1996 volume message. Page paragraph 6, my lord. Paragraph 6, my lord. Having gone through the record, we find more substance in each of the above contentions. Before conducting a search, the police officer concerned is required to call upon some independent and respectable people of the locality to witness the search. Here, that is available.
Read further. In a given case,
it may so happen that no such person is available, or even if available, is not willing to be a party to such search. It may also be that after joining the search, such persons later on turn hostile. In any of the eventualities, the evidence of the police officer who conducted the search cannot be disbelieved solely on the ground that no independent and respectable witnesses were examined to prove the search.
Must be an NDPS
But if it is found, as in the present case, that no attempt was made, even by the police officer concerned to join with him, some persons
that is interpretation of section 100, clause 4.
Who were admitted available witnesses for recovery, my lord. These are not stated anything.
Section 4,
Now,
section 100,
they are very old. Very, very old now.
You have argued for 1 and 4 only.
Only 1 and 4, others became, my lord, they are dead, it became.
All of them died.
All died.
1
and 4 are alive.
CORAM and 4
are alive.
Rest died.
All are dead.
All are died, yeah. See?
And they are at the fag end of their life.
No, all 9 died.
Barendra is now, my lord.
No, where is that? All died except. Which portion?
78. Barendra is 78.
1 minute.
And Sitaram is 85 years.
2, 3, 5, 7 and 8. What about 6?
6 is dead.
6 also died.
Yes.
The appeal survives only with respect to
1 and 4.
just see proceeding dated 9/4/2025. 9/4/2025 order. Also, acha, 6 and 7 also died. Okay. 9/4. So proceeding dated.
Six. For 6 is subsequently there.
1 minute. C.
1 and 6 in subsequent date, my dear lordship. Next date,
Proceedings
49.
dated 9/4/25.
Appeal and 6, my dear lordship, kindly see the order dated 14/8/2045.
And 14/8.
Yes.
14/8/2025. ठीक है.
Paragraph 2. Criminal appeal, appellant number 6 and 7 also stood abated. And hence the appeal appellant
A4 was 30 years at that time.
now is 78. 78 ना? हेले 30 हेले वर्तमान हेले 24 ये 10 12 38 38
30 ना?
Right. That's the 26, that is 30, 56, another 56, another 12.
कितना?
6.
71 years. And appellant 4 is 64 years.
नहीं, appellant 4 I am talking about.
Appellant 4 is, no, appellant 1 is, my lord, 37 years, that is another
4 years plus.
Year 12 or 30, 85 years.
85.
85.
No.
Appellant 1 to 85.
37, he was 37.
37. Now it is 38 years. 26 is that 12, 38 years. It appeals. Incident to रही ना. Incident appeal age no. इटा होची trial age टा पड़ी.
Trial court judgment, let us see. Trial court
judgment.
Let us see the trial court.
No, it's not trial court.
It's from some style now for
Trial court judgment 92. Why don't you see the charge sheet?
37.
Let us see the charge sheet. Charge sheet re Sitaram
43 internal.
Sitaram, just see Sitaram, what is it?
Sitaram, Jenna.
Charge sheet 25 plus. Charge sheet. Just see the charge sheet, but the exact page.
Trial court judgment achievement. 37 years. Later, 89. 89.
Incident.
74 years.
85 years. 84 or 85 years, my appellant number 1.
He says 74, you are saying 85, 10 years difference. Where from you are getting this?
My lord, 37 years. 37 years, it is 38 years now it has happened. 26, then 12. Incident to reason in 1988.
37 plus now 38 years.
38.
92 rule,
38.
78.
78, 78 years. And what about 4?
4 is 32 years. 32 years and 5 reduced above. 70 to 5 years. 73, 70.
State.
পঁয়ত্রিশ পা
এইটা ফেরিস উঠছে কেতে মিশু
30 বছর maximum, 38 years, 68.
68 years.
Appellant 1 is 74 years
Hmm.
and appellant 4 is 67 years.
Yeah. 74 years.
And 4 is 68 years.
And the entire life, no criminal antecedent at all.
Now you tell me in the, they have been convicted 395,
And
only 395.
395 force 60
conviction
conviction is
457.
457 and 9B 9B of Indian Executive.
In these cases, can the probation be granted?
Probation offenders can be granted, taking into account the age.
Because it is 7 years sentence.
Probation offenders.
Because A1, no problem. A1, there is no recovery from A1 and TI period also doubtful. So we can take out A1, no problem. But I am worried about A4.
Religion on probation of offenders. That no man criminal antecedent till death, my lord.
No, that's right. But whether in offense of this nature, probation can be granted, that's what I'm asking. Have you looked into it?
I have not examined that aspect.
You examine it and tell me. I'm reserving the judgment.
Yes, my lord.
So that A4 I can give probation. A1 we can remove.
I will examine.
A1 is as it is 74 years. 74 years A1. And TI period is doubtful, no recovery has taken place.
Imprisonment for life, so you.
Now, life.
Where is life? 7 years.
7 বছর বা 7 বছর maximum 7
Minimum is 7 years.
7 years
That's why
given. 7 years, 2 years, and 1 year.
We will round concurrently.
Check it up and tell me. Otherwise,
I will examine that aspect of it in respect of. Losses project, I will give a note on that. Commission note in respect of.
no, I'll put it Thursday. Thursday come.
No, Monday, my
What?
lord.
No, Thursday. Continue.
The other matters are there, therefore I can.
Only judgment Thursday. What is it? Big deal about? Again, I'll forget otherwise.
Thursday, my lord.
Thursday. Criminal appeal number 219.
My lord, I am seeking leave, my lord.
Thursday continue. With only you assist me on there.
No,
Because the
I understood, my lord.
new judgment which has come.
Yes.
That judgment says it is mandatory on the part of the court to consider why the probation will not be given.
Given. Taking
Now
into
the question is whether you are entitled to probation.
taking into the nature of the offense, my lord.
So therefore you have to tell me, find out from any high court judgment or any judgment, where in 395 also, if looking into the age.
I'll find out.
Age.
I'll find out.
And particularly the other accused persons have already died.
Yes.
One of them is going to be acquitted. So in that scenario, at least he can be granted the probation. That's all. And anybody is there? You are ready? Which matter is ready? You are ready?
Lordship, item number 21. I was appointed amicus curiae.
Item number?
21, Lordship.
Yes, 94 matter.
Lordship, I have not taken the brief. Today I will be taking the brief and will be arguing in the next day, Lordship.
Let it be there in the list. You
Yes,
take
sir.
it. Take it.
Today only.
Yes, Ms. Mishra, which one?
Any small matter I can.
Any small matter is there? Anybody is there for arguing?
Item 7, Lordship. Item 7 already.
Item 7, huh?
Yes, Lordship.
Huh.
I got instruction from the lower court counsel, Lordship.
I have also.
Previous day, Lordship, I
now.
What is this? Died?
died, Lordship. 3 of the appellants are died, Lordship.
All the 3? Which
Total
one?
number of appellants is 11, Lordship.
44 or
44, Lordship.
47?
44, Lordship.
What about 47?
44, Lordship.
There are two appeal, na?
Yes, Lordship.
And insofar as 47 is concerned, 47, how many appellants are there?
11 appellants in 44, Lordship.
And 9 in 47.
Lordship was pleased to direct the appellant on.
No. In 47, there are as many as 11 appellants. All of them died.
No, Lordship. No, Lordship.
Well?
Appellant 1, 2, and 11, Lordship.
That we know. That we know.
Last provision, Lordship.
No, 47. How many of them died? 1, 2, and 11, they've died already. 1 to 11. And their appeal has already been awaited by order dated 12/3/2026.
Who died?
1, 2, and 11 have died. You are repeating the same report. That we know already awaited. Death of to verify. You have verified, it's awaited. See, pursuant to order dated 12/3/2026, the State Council has obtained instruction after verification of the fact that the appellant number 1, 2, and 11 has already expired. Therefore, the present appeal, the appellant number 1, 2, and 11 stands abated in the absence of any application under Section 394 by the LR for the deceased appellant or their next friend. Abated. Next. What about
Lordship directed to release PO, Lordship.
What is the
conviction offenses, Lordship? 147, 323, 337, and 149 of IPC, Lordship. 6 months, 1 week.
PO.
PO, Lordship.
What about the other appeal?
Other appeal, 47, 47, 2020. 2010.
No, here how many appellants are there?
Appellants, number 1, 2, and 5 died.
Already expired. What is the offense here?
Same.
Same, Lordship. Same.
Huh?
Same, Lordship. And punishment is also same, Lordship. 6 months.
Same means what? Then I ये PO है तो दोनों.
Regarding appellant Muna Das, his whereabouts is not known.
Two appeals.
Two.
The other appeal? Both the appeals are there. 47 and
44.
44. This is 40? 47, 44. What are the offenses? Let us see. PO. I have written already PO. Here's the PO. Okay, PO, huh? Both the PO. PO. Abhedam. Dispose of.
Item 27. Wait, please, Your Lord's. Here, my lord, the appellant has been convicted for the offense under section 376, read with 3111 XI and XII of Asian ST Act, my lord. Last occasion, my lord was pleased to hear both of us, my lord, and was pleased to observe that section 3 is not made out. Section 3 of SC and ST Act is not made out. Pertaining to section 376.
Not made out for what reason?
No, here it has been stated that because of she is a girl of schedule, she schedule caste or schedule tribe, for that reason the offense has been committed.
Because he belongs to.
And that too, no document has been given by produced by the prosecution in that. Certificate has been given in that respect. And pertaining to 376, my lord was pleased to observe also that it's as though it's clearly a case of consent, but when 376 prescribes a minimum sentence of 7 years, whether it can be reduced or not.
Let us rephrase it. I think PW 5 is the prosecutrix.
My lord.
Let us recall that.
Well, let me see. At page 62. Well.
Yes.
She says, during the period of occurrence, I was working as a maid servant in the house of the accused. I was engaged to work in the house of the accused since about 1 year prior to the occurrence. In course of such employment, I was residing in the accused's house. The occurrence took place more than a year in the month of Pausa on a Wednesday. At the time of occurrence, accused Vikas was alone present in the house and his family members were not there. The accused dragged me to his living room and forcibly laid me on the palanque. He lifted me, so and so. I committed forcible sexual intercourse. Well, after committing rape, the accused told us that he would take me and his wife and threaten me that he would
Stab me with the knife.
If I disclose the occurrence to anyone. Out of fear, I did not disclose regarding the occurrence to my parents or anyone else. Thereafter, also the accused committed rape on me on several occasions.
One is dies, and another is alleged, and 6 months of increase.
31, huh? Who is appearing? Nobody is appearing, that's the problem.
One.
You got the report?
But one that report is this is the report that
Already, huh? Today.
The matter was taken up for hearing on 1/8/2025, comma 15/9/2025, comma 10/10/2025. Nobody appeared for the happenings. This matter has been listed several occasions in the weekly list. And the matter is called up non-API. Therefore, so is appointed as matter is to assist before. Next, Thursday. Sir. I have to appoint someone. Notice that. Okay. On that day, you will dispose of few over. Yes. 28, huh? Yes.
This matter, your lordship had heard.
Yes.
I had raised a question that the seizure on the 5th was not believable because of the entry made in the Malkhana register, which was said to be made on the 5th.
Exhibit 11.
Yes, which contained the TR.
Doubtful as a TR number written.
Yes. Now your lordship has.
Page 5449. What is that? Page 5449. Page 54.
If that document is seen, the lordship may see in the first column, the PR number is given. 190 by 120 by 97.9. The first column.
Exhibit 11, huh?
The place, date, and time of seized is stated to be on 5/1/1998 at 4 p.m. on the road at Canal Road, Kapileswara, Haripur, Patna, PS, Old Town, District.
Yes. I got it.
Now, your lordship, look at the last column headed remark.
One plastic bag, TR number.
Yes, TR number 1 of
198.
Now, on the 5th, if this has been entered contemporaneously, my submission will be that on the 5th, when this entry was said to be made, the TR number was not in it.
Yes.
Now, the explanation which the PW3 has given further buttresses the suspicion and makes it more suspicious. Your lordship may kindly look at page 42 of the case.
49.
42. I'm only placing the relevant facts.
Yes.
The first sentence begins on 5/1/98. I was sub-inspector of excise, GI and EB, Bhubaneswar. On that day at about 2:30 p.m., myself with my staff left for Old Town, Bhubaneswar for the purpose of patrolling, checking, collection of intelligence, as well as to watch activities of some suspects. And while we were patrolling at Old Town near Haripur Patna side, I was informed that suspect Bharat Bhoi would be coming to that area with some contraband excisable articles. Then you will ultimately go to page 45. Page 45, kindly look at paragraph 6, my lords.
Paragraph 5 read, paragraph 5 also.
Yes. Then I poured the ganja to the first gunny bag from the jari bag, took the weighment which came to 5 grams. Weighed ganja was kept in that jari bag, tied the mouth of that jari bag, kept it inside the first bag, tied its mouth, put paper seal on the bag, taking signature of the accused, witnesses and myself in a slip of paper, pasted it by means of lac called paper seal. Then he says, I seized the ganja and the bag MO1, prepared season list exhibit 4, read over and explained its contents to the accused and witnesses. Admitting its contents to be correct, accused and witnesses put their signature. Exhibit 4/1 is the signature of Anil Das, 4/2 of Bipin Das, 4/3 of S.A. Khan ASI, 4/4 of the accused. 4/6 is my signature. I handed over copy of the season list to the accused, who acknowledged receipt and put his signature 4/5. I arrested accused at the spot, examined the witnesses. I came to my office along with the accused, seized property, season list, etc., and kept the seized property in the Malkan. I also entered this in C7 case register, in which the case particulars, list of seized properties are maintained. It is called Malkanatam case register. So all these things he has done on the 5th of January.
Up to 2 o'clock.
I sent a detailed report of search and seizure to the Deputy Commissioner of Excise, and he gives the office copies marked as Exhibit 5. Now, your Lordship may see what he says in his further examination after the cross.
Page 49.
Yes.
Further examination. I have brought
the C7 register, the Malkhana register, from my office. I have kept the seized article in the office Malkhana. Accordingly, I have made entry in this register. This is that entry, Exhibit 11. In cross-examination, he says, it is not a fact that Exhibit 11 does not bear any date. The date is 5/1/98, which is mentioned against that entry. As per Form C7 of the manual, we are maintaining this register. Name of the register is Malkhanakam Case Register. It is audited regularly. The label indicating C7 case and Malkhana register is missing. Now this is important. After getting the PR number from the court, I mentioned the same against the entry.
That one of 90. Yes.
This, my lords,
is not a fact that I have
typewritten entry.
that you said that it is prepared.
It's not a fact that I have subsequently prepared Exhibit 11 to suit the case. Exhibit 11 has been made in my own hand, but I have not put my signature therein. Not a fact that register is not maintained in regular course of business in my office, for which there is no mention of the name of the register.
But generally these are done in the handwriting.
Yes.
You typed it out.
Typewritten document. How can he insert in a typewritten document in the column, my lords, after getting the case number?
No, it is prepared subsequently. Who types it? In the register, they generally entry it. Who types it? For the purpose of filing charge sheet, he might have done it.
Exactly.
That's very clear.
And who is his witness, my lords, on whom? Independent witness on whom the state is relying upon. For that, my lords, kindly look at page 38, the evidence of PW1. Now, the PW1 who is said to be the independent witness.
PW1.
Yes. I'm only asking your lordship to look at that part of the evidence. That is at page 38. And the bottom part, my lords may see, 7 lines from the bottom. The sentence begins, it is not a fact.
It's not a fact that I'm working.
Arrested in a case under the Case Act of Bolgad PS. I have been acquitted in that case. He denies having been arrested, says that he has been acquitted. So he establishes the fact that he is also a person having a background of having dealing in narcotics. This is the independent witness, and this is the evidence of PW3, the seizing officer.
Yes, what do you say?
That's why 16/10/2025 that hearing has concluded.
Hmm.
At that time, Rajabhushan Das is the AC, that file is not with us. The notes of something by Jilla, in this file time.
How would you explain this exhibit is manipulated? Exhibit 11.
And 23/12/25. As per the judgment was response for the petition and the parties are directed to file the written notes of submission.
You're not filed also. No,
No,
no.
that
I'll reject the judgment you file. Let them file, you file. This is the second time I have heard it.
yes.
You file written note of submission.
Notes of something.
Once judgment was reserved, again it was
Yes,
listed.
that 2 times.
To be
Ah.
mentioned, yes. There is the 13th hearing to be mentioned. 5th January. Written note submission in detail.
You have not filed, therefore it was again listed. Again I heard. Twice it was, see, 16/10/2025 it was heard. Again on 23/12/2025 it is heard. And written note of submission to be filed. You have not filed written note of submission. They have filed written note of submission.
Yes, sir.
So, twice this matter has been heard at length. Once on 16/10/2025 and subsequently on 23/12/2025, in judgment was reserved. Both the parties were directed to file written note of submission. Although the counsel for the appellant has filed the written note of submission on 3/2/2026, but the state counsel has not filed the written note of submission as yet. Therefore, the matter was listed today for further hearing. Both the counsel argued the matter at length, and now the judgment is again reserved, and the state counsel is directed to file a written note of submission within 2 days. Because it was given to Mr. Panigrai the other day.
Yes.
It was given, the copy of the written note of submission filed by them has been given to you. Yes, you should written it. Just see DP Panda versus and B Panda versus Sovan Padigri. It is given a copy, pencil it is written. The photocopy, I am getting a photocopy done now and I'm giving it. Yeah, our photocopy will be you. You have a extra photocopy? Yes, I will get it done. The written note of submission filed by Mr. Panda, which has already been placed on record. A copy of written note filed by Mr. Panda, which has already been placed on record, is supplied to who? Mr. Panigrai, you will take it?
Mine.
Mr. Panigrai, and who shall file written note of submission within a period of within 2 days, in 2 days. Copy kar do. That's good, judgment reserved. Just see Exhibit 5. What is your answer to that? And the independent witness appears to be a stock witness kind of. His version cannot be trusted in the sense that's what he says. Once he says that I was not an accused. Again he says that I was acquitted in NDPS case. He himself is an accused in an NDPS case, and European has him as a independent witness. So therefore, his trustworthiness of the independent witness is doubted. That's what the case is. and the exhibit 11 is manipulated, clearly manipulated. First of all, typed 1. Generally, it is never typed 1. The register they enter in hand. Typed, it's all right. That is the reason you typed it. That is the reason the TR number is written there. So it is prepared subsequently. Where is the original one? Where is the original register? Nothing. The typed one you have exhibited, and unfortunately there is no objection to that also. That's the problem. That's the whole difficulty. That should have been objected. It's completely a trust. Typed one, gore type one, any dog anything, etc. The defense lawyer should have objected to it, not objected. Somehow some cross-examination, something is said, that is the reason saving grace. Otherwise, it should not have been exhibited. Not even a photocopy. Completely typed. Yes. You concentrate there only. Yeah? Yes.
Item 40 again. Today, last occasion I told to file a fresh Bhinama, and I have no power. I have sent a letter to the appellant, but the postal return copy returned with the endorsement. He is deceased.
Item
40, my lord.
4040?
40, my lord. Mr. Gangadhar Tripathi was the conducting lawyer. After that, I got the file. And postal. Look. Endorsement says it is address is deceased. The front of the
Which police station is this? Don't open it.
So,
Which police station is this?
the commander, my lord, Lalbagh police station.
Lalbagh police station. You can get it. Address is Lalbagh.
Item 40.
He Vokalatnama nathila, then he sent it in Vokalatnama to his client.
Letter लिखकर contact कर देंगे. There are written as
Right now. Learned counsel appeal for the appellant submits that he had written a letter to this is the appeal pending since 2004. So as to get the instruction, further instruction, he had written a letter to his client. The letter had been returned with an endorsement that the addressee has expired. The endorsement dated 5/3/2020. The addressee has expired. The photocopy of the endorsement is based on the CORAM. A photocopy is based on the CORAM. In view of the aforementioned, the State Council is directed to ascertain the well-being status of the sole appellant, Prakash Behra. Prakash Behra. Prakash Behra. Day after tomorrow. In Lalbagh, day after tomorrow, you confirm it. Lalbagh. Because the postal remark indicates that he has already died. So we'll await it. Disposal. Day after tomorrow. Day after tomorrow. Let them verify. Lalbagh they can verify. Today only. Yes. तारा गोटे फोटोकॉपी नहीं जानतु आ गोटे कॉपी दी साइड रे फोटोकॉपी दे दियंतु सो दैट इजी इजी गो मैं कहि देबे चिट्ठी पठाई देले एंडोर्समेंट आछि दिस इज हां आ गोटे कॉपी कर दे फोटो फोटो दे दो व्हाटएवर दे हैव टू डू इट एज पर योर एनीथिंग एल्स ठीक है ओके